Good morning. My name is Kelly Blum. I am the Senior Associate in charge of the Community Association Law Section for FL Legal Group. We're based in Tampa, although my practice is statewide. Thank you for joining us. I've been practicing nearly 20 years. The bulk of that time has been community association law, and collections has always been a part of it, as as financial management. I'm going to be minimizing the video. You don't need to see my ugly mug, and I will have up for you to read along with me the slideshow. So with that said, there is a way for you all to ask questions. I'd ask that you hold off if you can till the end of the class. It's an hour-long class. It's easily an hour's worth of material. I'll try to rip through it fast enough while still giving you information that you're going to need. And just a quick note, there are changes coming effective July 1. Those changes are not reflected in the handout, but I will let you know about them and the impact that will have for your collections and financial management. So with that being said, let's go ahead and let's begin. Okay, so again, this is collections, financial management, and I do encourage my directors, my treasurers, my property managers to view collections as a significant part of the financial management of an association. Managers, not just managers, but managers, presidents, vice presidents, treasurers, secretaries should become intimately familiar with the terms of the declaration when dealing with collections matters. Very often, one of the first issues that comes up is a conflict between what the declaration provides and what the law provides. The law, in effect, at the time the declaration is recorded, is what typically governs. So let me say that again. If in 2000 or 1977, whatever the case may be, the declaration was written to provide for certain collection practices, and the law has subsequently changed, unless that law provides that it is to apply despite what's in the declaration, then the law for the year the declaration was written and recorded, actually, is the measure, is what governs and is what you all are going to have to abide by. That's why you always hear community association lawyers talking about the need to amend your governing documents, perhaps much more frequently than anybody would care to do so. Okay, so this creates the possibility where your association is going to be applying a law from an earlier time to a current situation. Okay, let's hold off for now on late fees, interest, and acceleration clauses. Assessments and installments on assessments, when not paid, bear interest at the rate provided in your declaration, and that interest accrues until the total sum due is paid. Under Florida Statute 718.116 and Florida Statute 720.3085, which you should become intimately familiar with, the interest rate may not exceed 18% per year. That turns out to be 1.5% per month if you are interested in the math. Okay. If the declaration provides, the association may, in addition to interest, charge what the handout that you're looking at provides is an administrative late fee. I don't care for that. I think that's a misnomer. It can provide for a late fee or an administrative fee, or both an administrative fee and a late fee. Those of you with management companies will know sometimes the association is charged an administrative fee separate and apart from a late fee. And if your documents are well written and you have a good collections policy and procedure, it will account for those things and passing them on to the delinquent owner. At any rate, late fees are capped. It's 5% of each delinquent installment, or $25 of each delinquent installment, whichever is greater. This is very important, okay? If you collect assessments on a quarterly basis and the $25 late fee is greater than 5% of the delinquent installment, you may not charge that late fee more frequently than you charge the assessments. I've known associations and lawyers that have gotten in trouble because they think they can apply a $25 late fee on a monthly basis, notwithstanding the fact that the assessments are collected on a quarterly basis, and that is simply not the case. So what happens when an assessment becomes delinquent? This is a really good point for me to talk about joint and several liability. An association can collect all past due assessments from a new member of the association. So let's say we have Mr. Smith, who is a delinquent unit owner in condominium ABC, okay? Mr. Smith, notwithstanding the fact that he owes condominium ABC 3 months worth of assessments, is able to somehow sell the property to Mr. Jones. Mr. Jones buys that property and is very surprised to find out that the association is owed money when he gets a letter from them saying, you owe this money. Mr. Jones's recourse is to then turn around and sue Mr. Smith, or to go after Mr. Smith for the money that he's going to have to pay. But make no mistake about it, joint and several liability provides that that new member is liable for the unpaid debt of the prior owner. So let's continue with the example, but let's say there's no sale. So we have just Mr. Smith, who's an owner, and he has not paid his assessments. What happens? Well, the association can record a lien, very often referred to as a claim of lien, in the official records for the county where the property is located. And what that does is it puts the world on notice that that association has a lien. And the lien can include the late fees that we discussed, administrative fees, interest, obviously the assessment, the unpaid assessments, and the attorney's fees and costs for collecting. When a lien is filed in the official records, it puts what lawyers will call a cloud on the title. So in the case where, going back to Mr. Smith selling to Mr. Jones, when Mr. Smith sells to Mr. Jones, if Mr. Jones doesn't do a title search or doesn't read his title search carefully, he will miss the fact that the association has recorded a lien, and that is a problem. Now, if the company that performs the title search for Mr. Jones misses it, that is their problem, because there can be liability for that. So that cloud, that lien, obstructs the homeowners and homeowner or unit owner, their ability to sell their property or even to refinance it. Now, this is where the change in the law that I referenced earlier, that looks like it's going to take effect July 1 of this year, may have some impact on the substance of the handout, the slideshow that we're reading. A homeowners association is unable to file a lawsuit to foreclose its lien until 45 days after that's been mailed to that owner. At present, it's 30 days for a condo, but one of the things that is proposed in Senate Bill 56 is that that number be increased to mirror the deadlines for HOA, so that will be another 45 days. The failure to comply with the 45-day or 30-day requirement, and again, the 30-day is presently, I believe it's going to be changed on July 1st, is that the association can then file a lawsuit. If, however, the association files a lawsuit before those timeframes expire, then that lawsuit can be dismissed and negate the association's ability to collect attorney's fees and costs, because the lawyer, or if the association is doing its own collections or has an agency doing it, is because they've botched it. Okay. Florida is what is referred to as a judicial state. That means you got to file a lawsuit to obtain a judgment. Okay. So typically, and certainly the way I do it, when I'm filing a lawsuit because an owner is delinquent and has not paid their assessments timely, I file a 2-count complaint, meaning I have 2 bases that form the relief that I'm looking for, that I'm asking the judge for. One is to foreclose the lien, and the other is for damages. Okay? You have the ability to sue for the unpaid assessments, the interest, any kind of administrative and or late fee, attorney's fees and costs when you sue for damages, but your leverage is really in putting the lien on the property, because the owner will typically want to keep that property. So what happens when you have a delinquent owner and the association wants to collect its assessments and there's a mortgage on the property? What can the association do to recoup its assessments from a lien foreclosure? Okay. This is a typical timeline for a delinquency. And you should know that historically, bank foreclosures have taken, in some cases, several years to complete. Now, I will tell you, some of my colleagues that represent banks and do bank foreclosures will vehemently disagree with me, but I think they are wrong. I think that they're not being completely truthful. As property values decrease, the banks tend to take much longer to complete a foreclosure sale. When property values are high, the bank, through their lawyer, is somehow miraculously able to complete a mortgage foreclosure, in some cases inside of a year. Perhaps it's cynical. I don't think so, although I'm from Miami, so you have to throw that in there. It seems to me that if a bank has a mortgage on a piece of property that was worth $500,000 at the time and is suddenly worth $250,000, that they may take their time waiting and hoping for that property value to increase back up to the $500,000 area, so that when they go to take title via their own mortgage foreclosure sale, they're not stuck with a debt on a property that is not worth the amount of the debt. So just keep that in mind. There are factors playing a part in this, and there are banks' policies on the amount of months before your file is transferred to the bank's attorneys. Other factors can include something simple like the attorney's workload and their ability to push a case through. Very often you have inexperienced attorneys that are working for the banks in a mortgage foreclosure arena. and obviously when the economy turns, the courts are very often flooded with bank foreclosures, and that is something that just getting before a judge can take several months. So a typical lien foreclosure, and I'm making the distinction between a mortgage foreclosure and a lien foreclosure, meaning the association's foreclosing its lien, can be done relatively quickly. Usually involves with, and you'll see here's this timeline where a unit owner or a homeowner is delinquent in January. The ledger is sent to the attorney in February. Now, I recommend no more than 30 days before a ledger is sent to the attorney. And there is a reason for that. In fact, there's a few. Associations historically have said that the association is not in the business of buying and selling real estate, and I certainly understand that. But if you're in a position where real estate has turned, where they're not ridiculously high sums of money required to buy a property like there is now, when that changes, the banks will take a long time to foreclose their mortgage, and that mortgage is a superior lien than that of the association. And what ends up happening is the association is named a defendant in that mortgage foreclosure, which is proper and necessary. That is because the association has an interest in that property, like any other person or entity that might have a lien on the property. The classic example is you have some sort of contractor, let's say a painting contractor went in to paint the interior of Mr. Smith's unit, and Mr. Smith decided not to pay. That contractor can put a lien on that unit. That lien is going to be inferior to the association's, and it's going to be inferior to the mortgage, but the mortgage lien is going to be superior to that of the association. So you should not delay. Because it can take banks longer, if you're able to file your lawsuit quickly, then you're able to get to the relief you're looking for quickly. So I recommend no more than 30 days. If you want to send a reminder letter, a couple of days or a day before a late fee is applied, that's fine. Interestingly enough, one of the changes that is being made in the law under Senate Bill 56 is that they're going to require what is essentially a reminder notice to the owners, telling them that they've got a delinquency that they need to pay, and providing 30 days to pay that. So keep in mind the timing of this now. If they're already a month late and you haven't sent that notice, and the law changes and requires you to send that notice, you're now going to be another 30 days late, and you won't be able to charge attorney's fees and costs or pass that on to the unit owner or the homeowner for that 30-day notice. So that's something that my clients and I are discussing about, whether or not that's something that the property manager is going to do, and what is the obligation of the association to the property management company for that added notice. These are all things that are going to have to be addressed sooner rather than later, because July 1, I believe, Senate Bill 56 will be the law of Florida. So, delinquent owner, getting back to the timeline, ledger sent to the attorney. The ledger must reflect a zero balance. Let me say that again. The ledger must reflect a zero balance. If a judge cannot look at that ledger, and that ledger will likely be evidence, okay, and determine when the debt began to accrue, you're not going to be able to prove your case, right? If the ledger, let's say Mr. Smith, let's say we've got monthly assessments of $100, Mr. Smith pays January, but he doesn't pay February, and he doesn't pay March, and April he pays. Okay, but he never catches up. When the judge looks at that ledger, if the ledger doesn't reflect January's payment, you're not going to be able to prove when interest began to accrue, for example, in February. You're not going to be able to prove when the debt for the assessments began to accrue, because if you just give him February, it looks like he's owed from the beginning of time. So you have to go back in the ledger far enough to where the owner was current on payments. Otherwise, you have an evidentiary problem. And if it doesn't exist at the time, if that ledger with a zero balance doesn't exist at the time the lawyer takes the case and sends out his first notice of intent to record a claim of lien, you may ultimately have a problem. Sometimes there's a balance forward if management companies have changed. You're going to have to eat some of that debt because the ledger needs to reflect a zero balance. Okay, so back to the timeline. Mr. Smith is delinquent. The ledger is sent to the attorney. The demand is sent to the owner. The demand that is sent in Florida in both HOAs and condos is very often referred to as a notice of intent to record claim of lien. It is required. Again, 45 days for an HOA, presently 30 in the case of a condo, but that appears to be changing. Once, let's say Mr. Smith has lost his job, he doesn't have any money, okay? Once the 45-day or the 30-day timeline expires, a second demand, which is also required under the statute, and which also provides another 45 days or another 30 days, if you're a condo, for that owner to pay the entire sum due. So keep in mind what's happening with the timeline. We've waited a month. Let's say we're in the case of a condo, and it's still 30 days, okay, for the owner to get current with the demands. You've waited 30 days. You send the letter. You wait 30 days. He doesn't pay. You send a second letter, a second demand. You wait another 30 days. You are now 3 months behind. Bear in mind, during a mortgage foreclosure, so not only foreclosure, a mortgage foreclosure, at the end of that case, it's typically the bank that takes title to the property. There's an auction. They have to make a bid. If nobody else bids because there's a huge mortgage that's owed on the property, the bank is going to get title to that property. All right? That bank is only going to be responsible for paying that association the lesser of 1% of the original mortgage or a year's worth of assessments. That's something that is in both 718.116 and 720.3085. It's a protection that the legislature has afforded banks. You know, their lobby is better than our lobby, meaning our community association's lobby. Okay. So the second demand goes out back to the timeline. The 45 days or the 30 days has expired. The association then begins a foreclosure action, meaning they file the lawsuit. The owner is then served with the lawsuit. Very often, that can take time. If the owner, lives upstate, if the owner doesn't reside in that particular unit, that particular property, sometimes you need to find them, and your roster needs to be up to date. I recommend to all my clients that there be a biannual roster update. Properties change hands, and you want to give the owners the opportunity to say, this is the address where I am to receive notice. Okay? If you file a lawsuit and it turns out that there was a notice sent to the association and about the new address where Mr. Smith is supposed to receive his notices, and you haven't done it, you're going to lose the lawsuit, because those pre-suit demand letters, the notice of intent to record claim of lien and the notice of intent to foreclose claim of lien, must be sent to the current address. Okay, let's assume we've got the correct address. Let's assume we get the owner served. The owner then has 20 days to respond. If the owner doesn't respond, typically if they don't have any money, they can't afford a lawyer, they don't respond, and the association can get a default. You want to make sure that your lawyer is on top of that. Day 21, he's looking to see if there's been a response, and if there hasn't, you file for a clerk's default, and what that does legally is prevents them from mounting any sort of defense. And the very next step, I like to sometimes combine clerk's default and a motion for summary judgment, is to move for summary judgment. And the standard there under Florida Rule Civil Procedure 1.510 is that there's no genuine issue of material fact, and that the association is entitled to judgment as a matter of law. Typically, it's 30 to 60 days before you can get a hearing. That, however, is much longer these days as a result of COVID. And if the economy turns and the court system gets flooded with a bunch of these cases, it's going to be much longer. So as I'm taking you through this timeline, think about how much time is passing before the association is in a position to either get paid or to sue and get a judgment so that they can put somebody in the property to rent it out and recoup the unpaid assessments that way. So you move for summary judgment, you get the judgment, and the judge will say, okay, as to count 2, you're awarded damages for X amount of unpaid assessments, X amount of interest, X amount of administrative and late fees, X amount of attorney's fees and costs. And in order to satisfy that judgment, I'm going to order the clerk of the court to sell the property at a foreclosure auction, and that can be set off. Florida Statute 45.31a provides that that sale should be 20 to 35 days out. Even when there isn't volume, getting the judge to order the sale of somebody's home within the 20 to 35 days can be difficult. That sale needs to be advertised by the party that has won their motion for summary judgment, so either the bank or the association. And so very typically there's a compromise that's made 45 days to 60 days to sell the property. I don't like doing that. I like setting it out for 35 days pursuant to the law and getting the sale done. Once that property is sold at auction, a certificate of title, not certificate of sale, but a certificate of title can be issued. That can take weeks, okay? And then a writ of possession, if needed, if the owner doesn't want to leave, can also take some time. So that is your typical lien foreclosure timeline. When an owner fights because the association, let's say, hasn't properly accounted for their debt or didn't apply a partial payment properly, or the accounting is off, it will take longer. Okay, so fundamentally, one of the questions and historically that associations have asked, or their directors and members have asked, is, hey, is it worth it to file a foreclosure? I do not, and typically what they're asking about is, hey, if there's a mortgage on the property, why would we do this? Because the bank is a superior lien. Well, first things first, you got to, as a director, you've got a fiduciary duty to the other members to collect the unpaid assessments. Okay? They owe, it's your job to collect. Collect. The bank, just by the very nature of it, they're huge, they're sluggish, they tend to employ younger lawyers to do the, inexperienced lawyers to do the mortgage foreclosures, because it's not terribly difficult. You need to be able to sell the property in your own community association lien foreclosure, and then rent the property out, because you can defend that mortgage foreclosure lawsuit while you're collecting rent. Okay? Now, in some cases, it may not be worth it, right? I'm talking primarily about the condition of the property. Does it need repairs? Does it need a new roof? Is there an electrical issue? Was it flooded? Is there mold? Okay, all these things matter, and a board can use its business judgment and determine, well, hey, wait a second, we're owed $5,000. It's going to take another $20,000 to put this unit or this home into a state of repair, someplace so that we can rent it out. So that's $25,000, and the mortgage foreclosure has just been filed. So is there a way for my lawyer to accelerate that mortgage foreclosure? And the answer is yes. I do it all the time. You accelerate that mortgage foreclosure so that you don't add to that debt of $5,000, the $20,000 that it's going to take to rehabilitate the property, just so that you can rent it out. Because if you're going to get $1,000 a month, it's going to take you 2 years and a month to recoup the debt. So it's not worth it. You're better off if there is a mortgage foreclosure, having that mortgage foreclosure accelerated. And there are ways to do that if you are the lawyer for the association. Okay, so let's say that they paid their mortgage, they just haven't been paying the assessments. You foreclose and you look to rent out the unit. You need to be mindful of the substance of the governing documents. Does the declaration provide that the board has the right to rent out units? Document amendments, may be necessary. Okay. Other avenues to collect. Well, if you have a landlord tenant circumstance, you've got an owner who has the property and it's an investment property, the association can intercept that rent, and that tenant is not liable to that landlord for any sort of breach of lease because he's not paying that landlord the rent. I've used this over the years. It can be highly effective if you have a tenant that understands. If you have a tenant that doesn't, get it, then that creates a whole other set of problems. Florida Statute 718.116(11)A allows an association to demand that the tenant make lease payments directly to the association until all past due maintenance fees or assessments have been paid. 720 has the same term. So if the tenant refuses to pay, right, what do? Because you can avoid having to foreclose if you have a tenant who's willing to pay and the debt is not that substantial. I tell my associations that you have these rights and you ought to exercise them. You have these weapons at your disposal. You ought to use all of them. You can collect rent from the tenant, but that's no 1 month, and that's no guarantee that the following month that tenant is going to go ahead and pay you the difference. So I am a big proponent of exercising the rights of the association because, again, you have a fiduciary duty to pay to those members to collect assessments. Okay. Collections policies and procedures should specify when an association will attempt to garnish the rent, or I would just say to collect the rent, and the process for doing that. The statutes 718 and 720 both provide specific details as to the notice that was required. You do a demand for rent is basically what's necessary. Okay. Good collections policy and procedure should also specify when the association will begin eviction proceedings should a tenant refuse to turn over rent to the association. Because most documents don't contain that, I am a big fan of not exercising that right. The association's best leverage is over that owner. If that owner is occupying that home or that unit, they're going to pay you if they've got it, or they're going to come up with it if they want to live there. You have a tenant can find a rental, another place to rent rather easily. And if you don't act to collect from the owner, you are, in my opinion, giving away your best leverage. Even if that owner is a landlord-tenant type, he's not going to want to have a property where he cannot collect rent. That's likely how he's paying the mortgage. Okay. Receiverships. If a unit is rented or leased during the pendency of a foreclosure action, the association is entitled to the appointment of a receiver to collect the rent. To me, it's an added and wasted expense. I don't need a receiver to collect rent from a tenant when the assessments are not being paid. You can have that tenant write the check directly to the association, care of the property manager, and be done with it. If you do appoint a receiver, the expenses of that receiver are also paid by the party that does not prevail. Again, usually the unit owner or the homeowner. When the economy is booming like it is, or while it's picking up, there are still associations that will carry bad debt on their books. That bad debt being those delinquent assessments. In 2015, Florida was the second leading state with foreclosure filings. I believe Nevada was number one. In 2018, 47.2% were in pre-foreclosure, okay? And that increased to nearly 70% from the previous year. So what happens with this, the reason for these statistics is to show you that once this starts to happen, okay, once you have a pandemic or once the economy turns, this picks up momentum. And you need to have in place a good policy, a good procedure, so that you treat everybody the same, so that you are meeting your fiduciary duty to those owners that aren't hit by the pandemic or that aren't hit by a turned economy, that are able to pay their assessments. Okay. Earlier I was talking about speeding up bank foreclosures. What are some of the specifics? Well, you can request an expedited foreclosure case. You can ask for an order to show cause, why entry of a final judgment hasn't been entered. There are things that, for example, when the bank files its complaint and not everybody is served, you can move for a default on behalf of the bank if they have been served and haven't responded. That's one way to get rid of some of those lien holders, like that contractor I was mentioning, who is just trying to collect the money he spent for painting Mr. Smith's the interior of his unit, and he's not going to have a lawyer, usually someone to protect his lien interests, because it's an inferior lien anyway. So it tends to be someone that you can get rid of in the mortgage foreclosure lawsuit. Okay, let's keep going. You can set the case for trial once the pleadings are closed. So that's a complaint, and that's an answer, basically. You can schedule case management conferences. Judges don't want to have 6,000 cases on their docket. So if you are in front of the judge asking the bank to move its butt, okay, to move its case along, you're going to have a friendly ear in the judge. They're going to agree with you that the case needs to move along. It is not that difficult. Either this person has paid the mortgage payment or they haven't. Either this person has paid the assessments or they have not. It is typically not a difficult case to prove. And to that end, you should, however, contact an experienced attorney to assist the association to use these defensive strategies in the bank foreclosure. Delayed mortgage foreclosures can end up costing the association thousands of dollars. Right? If you live in one of those associations where the board doesn't want to foreclose a lien, and it's a couple $100 a month, you're $2,500 a year. Well, at the end of 5 years, when that bank foreclosure is finally done, you're going to have a huge sum of debt that bank is not going to have to pay you. They're going to give you a year's worth of assessments. That means you've got 4 years that go unpaid. That's bad debt. That's on the director. That's on the treasurer. That's on the manager who didn't work to lessen your debt. Okay. So what happens after a bank takes title? Well, the association again is allowed to entitled to collect the unpaid assessments, and the question is how much. Again, years worth of assessments or 1% of the original mortgage. Look again to 718.116 and 720.3085. They provide the liability of a first mortgagee, which is usually a bank, or its successor. So back when there was a ton of mortgage foreclosure cases, back around starting 2007, some of those banks went under. Some of those mortgages were collateralized. They were securitized, bundled up, and sold off to other entities. Those other entities were successors to that first mortgagee or assignees. They were assigned that debt. They often could not prove it, but that I think has been dealt with. I think they're in a much better position now, having gone through that, where they're going to be able to prove that their ability to sue quickly. So they acquire title to a unit by foreclosure or by deed in lieu of foreclosure. That's basically where the owner says, hey, I don't want to fight, you can take the property. I'm going to go live with mom or something like that. Okay? That's again for the unpaid assessments that become due before the mortgagees, and it's a first mortgagee, folks. Acquisition of title is limited. If it's a second mortgagee, this safe harbor, this cap on their damages does not apply. So if you have a second mortgagee foreclosing and they get title at a sale, they owe every bit of the debt that's owed. That's not the case when you have a first mortgagee. Okay. I understand we have 15 minutes later, and I'm on page 17, which is a little less than halfway through. So we're gonna speed up here. Safe harbor. You can't charge anything but assessments on an estoppel. So an estoppel is a letter or a request that is sent to you by either the bank or a buyer at one of these foreclosure auctions. And when you have a first mortgagee that is requesting that estoppel amount, you can include the assessments. You cannot include attorney's fees, late fees, interest, or costs. Again, the bank's lobby is better than the community association lobby. They have more money. Legislatures will look you right in the eye and say, well, they're assuming all of the risk, so this is something we can do to minimize their risk. Well, you guys are assuming a risk too in a community association. It may not be the dollar figure that the banks are risking, but that's their job, that's their business, that's their choice. And but because they have more money and can get people elected, they get the law written in a way that benefits them, and as a result doesn't benefit you, the association, as much. Okay. Various districts have ruled that charges like late fees, collection fees, interest, attorney's fees are not collectible from the first mortgagee. That safe harbor does not apply. We've talked about the circumstance where it's a second mortgagee. That safe harbor, that cap on a first mortgagee's damages being 1% or a year's worth of assessment, whatever's less, it doesn't apply if the association was not named a defendant when the bank filed the mortgage foreclosure lawsuit. Okay? Now, let me tell you something about the lawyers for the bank. The ones that are good, the ones that know what they're doing. I have had them threaten, not me, but my clients, by saying, when they've forgotten to include my association as an original defendant, they have said, well, I will dismiss this lawsuit and I will file another one and I will name them in that, and I will say, I will pull your dismissal and complaint in this originally filed lawsuit, and I will make it Exhibit A to my motion to dismiss your lawsuit, or my motion to request that the judge not provide safe harbor because you didn't name us a defendant in the original action. And in every case, they have backed off and paid what has been owed. I suspect that if that happens now, they'll probably not back off and want to see where that goes. But we shall see. They've got to prove they're the original mortgage holder or a bona fide successor assignee. That just means when they're a successor to the first, mortgagee, that they need to be able to prove it. That's all that means. Okay, safe harbor continued. This is the Ocean Bank case. It's Ocean Bank v. Caribbean Towers Condominium Association. A judge in Miami ruled that Ocean Bank had taken title to 2 condominium units, and that they were entitled to attorney's fees from Caribbean Towers Condominium Association because the association failed to provide Ocean Bank with the safe harbor exception. So, don't try to be... Ocean Bank stands for the proposition that a board or its lawyer should not try to be slick and fight for more than just the unpaid assessments when the bank takes title as a result of the auction in the mortgage foreclosure action. It's not a good idea. Okay. Caribbean Towers did not prepare its estoppel certificates in accordance with the safe harbor regulations. Here's what that means. That means they asked for more than what they were entitled to. Okay? Can't do that. We're gonna go through Caribbean Tower because we're short on time. Fannie Mae, I'm going to skip through that. We don't need that. Estoppels, we've discussed estoppels already. There are deadlines for that. You should again look to the statutes I've referenced now several times for those deadlines. If an estoppel's certificate is delivered by electronic means, it must be effective for 30 days. If the estoppel is delivered by regular mail, then it must be effective for 35 days. Meaning, you commit to an amount, that's the amount for 30 days for 35 days. Let's keep going here. Estoppel fees. Association can charge $250 for the preparation and delivery of an estoppel certificate if no delinquent amounts are owed to the association. If delinquent amounts are owed, then an additional fee of $150 may be charged. Let's keep going. Yeah, the estoppels your lawyer will know about. I want to get through this a little faster since we're short on time. Waiver. The association waives the right to collect any amounts that are not set forth in an estoppel certificate. I had this come up where I represented an individual against an association that I obviously didn't represent. They did not include a sum on their estoppel when he bought, and then they threatened. Actually, they sent him a notice of intent to record a claim of lien because when they didn't include an amount, I forget the charge, on an estoppel, and I wrote back and let them know that they've waived that and they now owe my client my fees and costs, and that went away very quickly. Okay. There are deadlines. As I said, you got 10 business days to send the estoppel certificate. If you don't deliver it in 10 days, then you can't charge a fee for the preparation and delivery of the estoppel. Okay. More estoppels. I'm going to keep going through this. Okay, bankruptcy. The question is can an association, is it still entitled to collect maintenance from a homeowner or unit owner that files for bankruptcy? You need to know what chapter they filed under, whether or not that owner plans on keeping that property. When someone files for bankruptcy protection, that bankruptcy court, that judge enters an automatic stay. And what that stay means is you must immediately cease and desist all collection efforts. And I mean all collection efforts. If after they filed, you send a letter, you send a reminder notice, you do anything geared towards collecting, you will have violated that stay. And that federal judge will perhaps take great glee, because I had one tell me I live in an association too, in sanctioning the association and or its lawyer. Okay. Chapter 7 is liquidation, where the owner divides non-exempt property based on the priority of claims. I mentioned earlier lien priority and how a mortgage is superior to the lien of the association. There are certain liens that are more superior than a mortgage, for example, a tax lien. In Chapter 7 involves a complete discharge of all the debt, including deficiencies in judgment. The lien is, however, still valid, and the lender can continue to foreclose if the debtor, meaning the delinquent owner, is surrendering the property. The lender will seek, meaning the bank, will seek to lift the stay. Usually what happens is an association files what's called a proof of claim. Chapter 13 is different. It's a personal reorganization. We have 5 minutes, so I'm going to go through this. Bankruptcy is a specialty, and your lawyer should know what to do if an owner who is delinquent files for bankruptcy protection, or should have a bankruptcy lawyer that they recommend for handling that part of the collections process. Okay, let me keep going here. That's it. We have 5 minutes. What I need to know is, hold on, where do I minimize this? Let's see here. Okay, I'm going to minimize this and see if I have any questions. Okay, let's see. Live chat, I don't see any. Okay, live chat. Let's see here. Okay. I seeing no questions. I don't see any. Let's see if I have. Okay, no. Okay. Well, that'll conclude the class then. Thank you so much for your time, and I'll see you next time.